you hear me? Welcome to Hidden Secrets Revealed live on today's broadcast on Hidden Secrets Revealed Live. That's what this is. Welcome. Thank you. Okay, check this out. Andy Warhol's Prince paintings are in the Supreme Court. They're in a Supreme Court copyright case. Alliteration, Supreme Court copyright case. Andy Warhol's Prince paintings. Today, let's talk about it. What is art? What are the boundaries? Let's talk about it today on Hidden Secrets Revealed Live. Welcome today on Hidden Secrets Revealed Live. We talk about Andy Warhol and a copyright issue that is in the Supreme Court right now. HSRL, that's an acronym for Hidden Secrets Revealed Live, by the way. HSRL is a production of Safe New Media. Who this is for, self-actualizers, making the most of their lives. This micro podcast live stream is not for you if you take yourself too seriously. Listen to the new single. I have a new single out now. It's called In the Secret Place. Go to safenewmedia.com/singles for details. I'll play at the end of today's show. I'll play some of the song today before we end. Listen to my new single. Get on the list. There's a link to get on the list for my holiday release that I have coming out. Details to follow. But it is a single that is a synth rock, sort of synth pop rock Christmas Hanukkah song. Get on the list. There's a link in the description and info on my Twitter. By the way, are we friends? Are we friends on Twitter? Come on, guys. Let's be friends on Twitter. Are we friends on Twitter? Come on. Just be my friend on Twitter. Come on. I appreciate you guys. Thanks for watching. There's a Telegram. Telegram Sam. If your name is Sam, join the Telegram. If you are a seeker, let me be your guide to discover divine truth for yourself. Let me help you to increase the quality and effectiveness of your life by revealing to you the hidden secrets of the universe. Hidden Secrets Revealed Live is a production of Safe New Media, unconventional, diversified global digital media company devoted to the practice, administration, and dissemination of the ideologies of its founder, yours truly. It is not a cult. It's definitely not a cult. Nothing to see here. Once again, I invite you, especially if you're watching on, right now I'm broadcasting live on Facebook, on LinkedIn, and on YouTube. The reason I do more than one channel at the same time, I'm on Facebook, I'm on LinkedIn right now, and on YouTube right now, because you gotta be decentralized. If one gets taken down, there's two more up. Huh? And also, instead of talking to you in those places exclusively, like I don't talk to anyone on Facebook hardly anymore. Now there's just Telegram. I like Telegram. It's not as crazy as Discord. That's why. So let's get into it. Come on, if rambling so much, just stop rambling, Fen. Come on. All right, here's the deal. This week, the U.S. Supreme Court will hear a case centered on an art question with few easy answers. Did Andy Warhol violate photographer Lynn Goldsmith's copyright when he used her photograph of the music legend Prince as the basis for a series of portraits? This is gonna bring up questions of authorship. This is a very interesting case. Also, uh, today's information comes from Art News. Goldsmith filed the initial complaint against the Andy Warhol Foundation, alleging copyright violation in 2016. In the years since, the case has made its way through the lower courts, eventually reaching the U.S. District Court for the Southern District of New York, who ruled in 2019 in favor of the Andy Warhol Foundation. Now, last year, the appellate court, which hears appeals and is typically the last word in most cases, reversed the Southern District Court's decision. Okay, I'm giving credit to Art News for this. I'm appropriating Art News. This is art. You're watching an artist at work. The Warhol Foundation appealed the case to the Supreme Court, which will hear arguments beginning today. They probably by now they've heard the arguments. Today is the 12th of October, 2022. For the record, at the center of the case is Goldsmith, a celebrated portrait photographer who has photographed nearly every major music celebrity of her era, from Nirvana to Bob Marley, and shot over 100 album covers. In 1981, Newsweek commissioned Goldsmith to photograph Prince. The magazine did not end up using those photos, right? However, Goldsmith retained the licensing for future use. 3 years later, Vanity Fair commissioned Andy Warhol to create an image of Prince for a cover and paid Goldsmith a license fee to use one of her images as the reference point, the reference photo, if you will, with the understanding that it would only be used for that issue. Got it? So this is where things get murky. Goldsmith claims that Vanity Fair withheld that Warhol was going to use her image in his illustration and did not inform her that Warhol created 15 more silkscreen illustrations based on her photograph. Those illustrations were copyrighted by Warhol and have since been sold and reproduced for hundreds of millions of dollars. Don't know exactly how much, but it's hundreds of millions of dollars, right? Okay, so Goldsmith claims she had no knowledge of the silkscreens until 2016 and is owed millions in unpaid licensing fees. The Supreme Court's decision will likely hinge on whether the justices view Warhol's use of Goldsmith's image as fair use, as the Warhol Foundation has argued. Is it fair use or is it not fair use? The Supreme Court, that's what they're deciding right now, today. Fair use is a legal doctrine in copyright law that promotes freedom of expression by permitting the unlicensed use of copyright protected works in certain circumstances. This is according to a description as Copyright Office. There are 4 factors that courts consider when determining fair use. Number 1, the purpose and character of the use. Is it commercial, educational, etc.? Number 2, the nature of the copyrighted work. Is it a news article is more likely to be subject to fair use than a creative work like a movie or song. Got it? Number 3, the amount of substantiality of the portion of the work used. And number 4, the effect of the use on the market or the value of the copyrighted work. Okay, so those are the 4 criteria that the US copyright law considers for it to be fair use. The first factor is likely the most important one in this case, as an used defense is that the use is transformative. I've I've done that myself as an artist. Mhm. Transformative use. That means that the original copyrighted work has been transformed by the new creator to such a degree that new character or meaning is present. In this case, it is likely that Goldsmith will argue that Warhol's use was not transformative, that his print silkscreen is demonstrably still her photograph, and no new meaning has been created. Here's where this is where it gets really nebulous. Okay, the Warhol Foundation will argue that it is transformative. Making deliberations in court on an artwork's purpose and character is a very tricky business. The court system, this is a quote, the court system wasn't intended to make judgment calls about the artistic value of something. That's a quote from Kelly S. Gordon, an intellectual property lawyer who often works with artists. Okay, Kelly S. Gordon tells this to Art News. There's a fine line there in terms of making a judgment call as to the importance of the work within art history versus whether if the work is transformative. End quote. This not only brings up a question about fair use. This is me talking. This is this is not this not only brings up a question about fair use, right? But of ownership, originality, as well as source material. Okay, think about it. If an artist uses a photograph as a reference to make a painting, is that considered copyright violation in in situations like this? Artist Barbara Kruger and curator Robert Storr jointly filed an amicus curiae brief on behalf of the Warhol Foundation, arguing that artists have always referenced and copied each other's work. Kruger's work is used as a primary example. Okay. Kruger views photographs and other visual media as constituting hard evidence of contemporary cultural life. By using pre existing photographs and videos, Ms. Kruger's work is able to engage directly with this evidence, effectively annotating the visual artifacts of our times. Okay. This is from the attorneys of Barbara Kruger and Mr. Storr, the curator. The brief concludes, for many artists, the artistic message they seek to convey lies precisely in a verbatim or near verbatim replication of the original work. Kruger and Storr are arguing that a tightening of the fair use doctrine would have a detrimental effect on the creative process. In effect, artists and content creators, fearing costly litigation, may abstain from using or referencing copyrighted work and thus limiting cultural exchange and discourse. Is that not the logical conclusion? In a recent piece for The Atlantic, media lawyer and filmmaker Paul Sinal Un momento, por favor. I need, hang on a sec. I need to power up. Sorry. Okay. Paul Sinal. Sinal. He's a filmmaker. Says that this case is about more than a quibble between visual artists, but about an existential threat to the freedom of expression in the US. Any ruling in favor of Goldsmith, he wrote, would be culturally disastrous. Do you agree? Leave a comment. Smash that subscribe button. Pummel that subscribe button into submission. It helps this channel grow. I talk about art. That's one of the major things that we need to talk about because it's so important to our culture. If you're watching on LinkedIn, on Facebook, on YouTube, smash that subscribe button. If you're on YouTube, smash that subscribe button, pummel that subscribe button into submission. If you're on LinkedIn, share this. If you're on Facebook, share this with somebody. Even if you make fun of me, I don't care. If you do leave a comment that makes fun of me, I just want it to be funny. That's all I ask. Also, if you have, some insight, or if you're an artist and you have a perspective that is valuable, please leave a comment. Okay, so according to filmmaker Paul Sinal, this is disastrous. He continued that because the Supreme Court's decision will generate a principle that will apply beyond this dispute, Goldsmith is attacking not just this particular use, but potentially all forms of art that rely on similar techniques. A long history of appropriation artists, and copyright lawsuits. Okay, there's a long history. Andy Warhol is not the only artist to have been brought to court for allegations of copyright violation or appropriation. Richard Prince, Jeff Koons, Shepard Fairey, Nadia Plessner, and Barbara Kruger have all been sued for copyright infringement with varying results. This year, Ryder Ripps, the post-internet artist, was being sued by Yuga Labs, the parent company of NFT collection Bored Ape Yacht Club, for a number of alleged violations related to his NFT collection, RR/BAYC. Have you guys seen that? It's interesting. Ryder Ripps essentially appropriated BAYC. Okay, for that collection, Ripps appropriated images from the BAYC collection in what he has described as satirization of the collection and NFTs as a whole. He's making fun of it, as he should. It's ridiculous. That's why I love it. Perhaps the most famous recent such case involved American painter and photographer Richard Prince. Famously, Richard Prince does this. Remember this? In 2009, Richard Prince, not Prince, the artist formerly known as Prince, but Richard Prince, was sued by French photographer Patrick Carriot for copyright infringement after his Canal Zone paintings incorporated photographs from Carriot's 2000 book Yes, Rasta. In March 2011, a U.S. district judge ruled against Prince and ordered the defendant to destroy any unsold paintings that borrowed imagery from Carriot. That ruling was largely overturned on appeal a year later, apart from 5 paintings that were ordered to be re-evaluated for claims of fair use. At the time, NYU art law professor Amy Adler told Art in America, where this is the story is from. Okay, I'm appropriating Art in America right now. I'm sorry, Art News. But this is just, by the way, I'm appropriating Art News by giving you this story right now. But this is from NYU art law professor Amy Adler, who told Art in America, another publication, that the decision was a major win for Prince. Okay, this is a quote. from Amy Adler. The court decided that the artwork does not need to comment on previous work or qualify as fair use, and that Prince's testimony, Richard Prince, she's referring to, is not the dispositive question in determining whether a work is transformative. Rather, the issue is how the work may reasonably be perceived. This is the right standard because it takes into account the underlying public purpose of copyright law, which should not be beholden to statements of individual intent, but instead consider the value of all of us gain. You and I, the admirer of the art, the viewer of beauty, me and you, other people, all of us. Anyway, I'm going to shut up, and I'm going to just repeat the last part of her quote. Okay. Um, okay, she says this is the right standard because it takes into account the underlying public purpose of copyright law, which should not be beholden to statements of individual intent, but instead consider the value that all of us gain from the creation of new work. The waffling between lower and higher courts over Prince's paintings' merit eventually came down to whether a reasonable observer would find Prince's works to have been transformative and thus protected under fair use law. The question remains, who is a reasonable observer? That's the term, the reasonable observer. That's the term I was looking for a minute ago when I started rambling. I digress. Who is a reasonable observer? New York attorney Sergio Munoz Sarmiento told Art in America following the ruling. Kruger and her fellow appropriation artists may say that fair use challenges are an inevitability of art making. Artists are obviously indebted to the innovations of their predecessors. That's just art history. And many great entries were born somewhere between inspiration and appropriation. But is art historical merit a valid legal defense? The Andy Warhol Foundation for the Visual Arts has proposed one solution. Art historians and other experts should have a say in cases where the aesthetic meaning of a work isn't obvious to the naked eye. It was an argument similar to the one made by the Rauschenberg Foundation, which came out in support of Richard Prince during the lawsuit against him. Okay, but then there's another question to consider. Does an impartial art critic exist? Impartial art critic. That sounds like an oxymoron, doesn't it? In the American legal system, there is no impartial expert. Each side introduces an expert and argues why his or her expert is the superior one, says Nicholas O'Donnell. That's not me talking. That was Nicholas O'Donnell. Nicholas O'Donnell is an art lawyer and co-chair of the Art, Cultural Property, and Heritage Law Committee of the International Bar Association. An art history issue or a licensing issue, what is it? Okay. In O'Donnell's view, Goldsmith versus Warhol comes down to fundamentally a licensing issue. Arguing about transformation misses the point. It's a licensing issue, according to O'Donnell. It's a good point. It kind of is a licensing issue. This dispute is about the Warhol Foundation decision to take someone's money for a license in 2016 on Prince's death, he said. Big newsworthy story. People are looking for images of Prince to use in magazines, and there's a direct displacement of Goldsmith by the licensing of Warhol's silkscreen. That is a very good point. Framed that way, the case is about markets, and money, not meaning. Huh? Let me say that again, because that was good. That's actually framed that way. Okay, that this dispute. We're going to repeat the quote from uh, the quote from O'Donnell. This dispute is about the Warhol Foundation decision to take someone's money for a license in 2016 on Prince's death, he said. Big newsworthy story. People are looking for images of Prince to use in magazines, and there's a direct displacement of Goldsmith by the licensing of Warhol's silkscreen. He answered, that's it. It's about markets. It's about money, not meaning. Anyway, I'm going to wrap it up in a sec. Thanks for watching. I appreciate you guys. Smash that subscribe button. Okay, so I'm gonna conclude in a minute, okay? But I'm gonna wrap it up with this. So far, many dealing with the Warhol case have attempted to sidestep the question of merit. The appellate court, for example, looked not at Warhol's artistic style, but at the conditions of his works making to determine copyright violation. It pointed out that the photo had been licensed for one-time use with credit to Goldsmith, that the photo was then used 15 more times without Goldsmith's knowledge, that the series was then licensed to Vanity Fair to commemorate Prince's passing, and that no credit was given to Goldsmith. They tried to take this art neutrality position that they're not really here to make that judgment. This is a quote from Gordon about the appellate court's decision. The concern was that because Warhol is so well known and so famous that may affect the balance of whether he is making a new message or not. But if it's an unknown artist with not much work, it would be harder for a court to decide if there is a new message or meaning. Okay, this is still Gordon talking. And I'm quoting here. There's a concern that the person accused of infringement may make something up, and the courts aren't positioned to make an accurate judgment. I'll conclude with that. And you've just witnessed me appropriating art news and making it an episode of Hidden Secrets Revealed live. See what I did there? That's very Warhol of me. So thank you, Art News. What do you think? Is this copyright infringement? Or is it just, there's no meaning, it is just about money and markets? I tend to agree with that viewpoint personally. But what do you think? It's not about me, it's about you. What do you think about me? I appreciate you guys. Once again, let's be friends on Twitter. Come on, guys. Let's be friends on Twitter. All right, I'm going to wrap up today's episode of Hidden Secrets Revealed live with a few seconds of my single. But before I do that, I'm going to play you a little I'm going to pepper in a little commercial about something that has really helped me. As you can see, sometimes I have a hard time focusing, and this is what helps me. Imagine how horrible, how much worse I would be without this. This is my go-to, no-brainer stack, effing clarity and effing focus. I love it. It works for me. Try it today. There's a link in the description. Try effing focus. Eliminate brain fog with effing focus. It works. Swear by it. Going to leave you now with a few seconds of my song, my latest single. It's called In the Secret Place. Appreciate you guys watching. Share this with somebody. Leave a comment and subscribe, and then ring that little notification if you're watching on YouTube, because I go live on Mondays, Wednesdays, and Fridays. And on Fridays, I go live on Twitch. All right, I'm going to shut up and leave you with 57 seconds of my single, In the Secret Place. I appreciate you guys watching. Before I let you go, this is my catchphrase. I have spoken.
If your tongue were a rudder on the ship of your life, smaller than the sails catching wind, the wind of intention guides the dream.